Thomas G. Moukawsher is a former Connecticut complex litigation judge and former co-chair of the American Bar Association Employee Benefits Committee. He is author of the new book, Common Defect Unnecessary Complexity in Courts and 50 Ways to Reduce It. CNN. Although it was read as a defeat for former President Donald Trump, who wanted to push date back even further, the defendant actually won a partial victory in terms of his top legal strategy by extending lawsuits against him until after 2024. Vote. Thomas Moukawsher. Courtesy of Thomas Moukawsher. It's significant that Cannon and the judges in the other 3 criminal cases didn't buy into his own strategy. Fortunately, referees have a few ways to stop his delaying tactics if they want to employ them. Cannon is the Florida federal judge presiding over the case examining whether Trump mishandled classified documents at his Florida home. She gave Trump some time he wanted by extending some of preliminary hearing period's case, while keeping same trial date. The closer pretrial proceedings are to hearing date, more likely hearing will be postponed. There is too much work to be done at once. Moreover, Trump did not actually lose his bid postpone trial date. The judge ruled that matter was premature to rule at this point and acknowledged Trump's complaints about amount of evidence his lawyers had sort through before trial. A delay in court often leads to other demands, so Trump still has reason to hope. Trump's lawyers' maneuvers are all part of their tactics to stall the cases. As an expert on American litigation, Trump knows that delaying a trial can often derail it, and he's betting heavily on that. Delays cost time and money. The evidence disappears. Memories are being erased. Prosecutors, judges, even presidents come and go. Charges can be reduced. Sentences reduced. Maybe even everything could be dropped. The first way to delay a case is to flood it with motions. First of all, you question where the case is. For example, Trump claimed that the election trial should be moved from Washington, D.C., because it could not have a fair trial there. You then attack the people who filed the lawsuit and claim that they have no legal interest at all. Trump attacked the election case on this basis. You then attack the way the claim was prepared. It is flawed and should be rejected. Trump is also using it in D.C. and Georgia. Each motion, filed and heard separately, can take months to resolve. Abstracts filed. Opponents' briefs are filed. The request is being argued in court. The judge finally writes a decision and the next motion is presented. That way, if judges follow regular court process, Trump could keep the lawsuits going for years, especially until after 2024 election. Moreover, Trump can use the number of pending motions to justify proposals that need more time. That's what Cannon got into. You create work and then complain about the volume of it. Judges can prevent this by controlling the flow.